Good day, this is my report, Title 8, Lease, Chapter 2, Lease of Rural and Urban Lands. In Section 2, we discuss the rights and obligations of the lessor and the lease in Article 1655 to 1660. In Article 1655, if the thing leased is totally destroyed by a fortuitous event, the lease is extinguished. If the destruction is partial, the lease may choose between a proportional reduction of the rent and a rescission of the lease. Comment 1. Effect of a total or partial destruction. Note that the law says destruction, total or partial. In case of mere deterioration, the remedies referred to in this article do not apply. In case of a destruction, the article applies. In total destruction, a specific, unique, antique base you agreed to sell is accidentally smashed into irreparable pieces before you could deliver it. So, in total destruction, in example 1, a student rent an apartment near school. One day, a strong fire breaks out and entire apartment is burned down. The place can no longer be used for living. So, this is total destruction because the apartment no longer exists in a usable form. The law on destruction applies, so the obligation related to the apartment may be extinguished. So, in example number 2, partial destruction. A student rents a small house during a typhoon. Half of a roof is destroyed and one room becomes unusable, but the rest of the house can still be lived in. So, this is partial destruction because only part of the house was destroyed. The law on the destruction will apply because something essential was destroyed. Okay, in example 3, mere deterioration. A student rents a boarding room. Over time, the walls get dirty, the paint fades, and the door becomes old, but the room is still usable. This is a mere deterioration, not destruction. But this mere deterioration law does not apply. The law on destruction does not apply because the room still exists and can be still used. So, the law applies only when there is a total or partial destruction, meaning the thing is completely or partly destroyed and cannot be used properly anymore. If the thing only becomes old or worn out but is still usable, it is only deterioration and the law does not apply. Example 2. In the lease of contract 5 years, fire caused by lightning completely destroyed the house. Lease at the end of 3 years. Is the lease responsible for the remaining 2 years' rent? Can he demand that the lessor reconstruct the house? Answer: no, because the lease has been extinguished. He cannot, on the other hand, demand that the house can be reconstructed. So, here are the cases. Scenario: the Coastal Cafe lease. Imagine, Anna owns a seaside property consisting of a modern glass cafe, building and a small garden lot. She leases the entire property to Ben for 5 years. So, partial destruction. The lease has a choice. A. Proportional reduction of the lease rent retroactive to the time the partial destruction was caused. B. Or rescission of the lease, but only if the destruction is of significance, because as a rule, rescission should not be allowed for a trivial causes. A contrary rule may result in the instability of contractual relations. So, 5. Illustrative problem. A was leasing a house owned by B. The house was partially destroyed by a fortuitous event. The lessor B wanted the rental reduced, but A insisted on rescinding the lease. Who should prevail? So the solution in this scenario, A, the lease should prevail. Here's why. Number 1, partial destruction. Since the house was only partially destroyed, the law provides option for both the lessor and the lease. The lessor can option to repair the damage, while the lease can ask for a proportionate reduction in rent. Number 2, lease option. However, if the lease prefers to rescind the lease due to the partial destruction, they have the right to do so, especially in the destruction is significant enough to make the premises unsuitable for the intended purpose. In number 3, the fortuitous event. The destruction was caused by a fortuitous event and unforeseen and unavoidable event. Neither party is at fault. This further supports the lease right to choose rescission as a remedy. So, the lease A should prevail in rescinding the lease because in the event of partial destruction due to the fortuitous event, the lease has the option to either seek a reduction in rent or to rescind the lease if the damage is significant. So, the Article 1656. The lessor of a business or industrial establishment may continue engaging in the same business or industry to which the lease devotes the thing leased, unless there is a stipulation to the contrary. Comment. The lessor's right to continue engaging in same business or industry. So, the answer is the general rule is that a lessor has the full right to continue or start engaging in the same business or industry that the lease or tenant was conducting on the leased premises after the lease contract has expired or terminated. So, this provision means that the lessor or owner has the right to continue or start with the same kind of business as the lease, even if affects the lease's business. The reason for this rule that the lessor does not guarantee that the lease business will be successful. When someone rents a place, the lessor only premises the uses of the property, not protection from the business competition. Also, competition is not considered a juridical disturbance. Juridical disturbance refers to a legal actions or claims that interfere with the lease precision, just as when someone legally claims ownership of the property. Since competition is a part of doing business, it is not a legal disturbance. As explained in the City of Naga Court of Appeals, a lease cannot complain if the lessor or other engage in the same business because business risks and competition are normal. So, may the lessor begin the business. So, yes, when the law says the lease may continue does not apply when the lessor is already operating a business. It also applies even if the lessor is just starting, for example, beginning construction, renovation, or repairs for that business. The reason is that purpose of the law is to protect the lease. As long as the lease can still safely and properly use the rented place, the lessor is allowed to begin construction or repairs related to the same business. In short, what matters is not when the lessor starts the business, but whether the lease's right to safe and the suitable use of the property is respected. So, example number 3. A lease A lease to a B, a business establishment dealing in a sale of shoes. A is allowed to also engage in the shoe sale business unless there is a stipulation to the contrary. Here are the scenario. Lessor may engage in the same business. Mario rents a commercial space from Leo to open a bakery. The contract does not say anything that prohibits Leo from opening a bakery. After a few months, Leo built another store beside the rented space and also opened his own bakery. Mario complains and says that Leo is hurting his business and disturbing his lease. Under Article 1656, Leo is allowed to do this. The law says that the lessor may continue or engage in the same business or industry as the lease unless there is a stipulation to the contrary. Leo did not promise Mario that he would not compete, and the lease contract did not prohibit him from opening a bakery. Also, competition is a normal business risk and not a juridical disturbance. Therefore, Leo has the right to open the same business and Mario cannot cancel the lease just because of competition. Article 1657. The lease is obliged to pay the price of the lease according to the terms stipulated. 2. To use thing lease is as a diligent father of a family, devoting it to the use stipulated, and in the absence of stipulation, to what which may be inferred from the nature of the thing leased, according to the custom of the place. 3. To pay the expenses for the deed of sale. Comment. Duty of lease to pay the lease price or rent. Who fixed the rent? The rent is fixed by the lessor, not the court. For this is consensual contract. If the lease does not agree, there is no contract of lease. Rent B. Rent not fixed in consignation case. When a lease contract expires and the tenant holds over continues occupying the property, they must continue to pay rent. If the amount of the new rent has not been fixed by a new agreement or by the court, a problem arises when the tenant tries to use consignation to pay the landlord who is refusing payment. What the court can do? Well, it is clear that the court cannot fix the rent save possibly in the case contemplated under Article 448, where a builder has built in good faith a building on land belonging to another, but the value of the land is considerably more than the value of the building. Still, once the rent is agreed upon, the court can fix the time when said rent is to become effective. Letter D. Increase in rent. As we have already intimated, when a lease refuses to pay rent, he may be ousted. Naturally, this duty to pay rent arises only if the subject matter of the lease has been delivered. From Sugar Estate and the comment thereunder. Number 2. Duty of lease is to use properly the thing leased. A. The lease must be exercised the diligence of a good father of a family. B. The use must be confined 1. To the stipulated. 2. If one was stipulated. To that inferred from the nature of the thing leased, according to the custom of the place. No. An illegal use, just as prostitution, allows the lessor to end the contract. 3. Duty placed to pay the expenses for the deed of lease. Observe that while in the sale, it is the seller who generally pays the expenses for the deed of sale. In the case of lease, it is the lease who generally must pay the expenses for the deed of lease. Generally, said Expenses should include those for the registration of the example, obligation of the lease. Scenario. Anna leases a small apartment from Ben. Under Article 1657, Anna has the following obligation. 1. To pay the price of the lease according to the terms stipulated. If the monthly is rent 10,000 pesos due every 5th of the month, Anna must pay on time. 2. To use the thing lease as a diligent father of a family. Anna cannot damage the apartment. She must take care of it, use it only as a residential dwelling, and follow the usual practices or custom of apartment living. No loud parties that disturb neighbors, proper maintenance of facilities. Number 3. To pay the expenses for the deed of lease. If notarization or registration of the lease contract costs 2,000 pesos, Anna is responsible for paying these expenses. So, in Article 1658, the lease may suspend the payment of the rent in case the lessor fails to make the necessary repairs or to maintain the lease in peaceful and adequate enjoyment of the property lease. So, comment. Number 1. When lease may suspend the payment of the rent? The answer is, the lease may validly suspend the payment of rent in the following instances because the lessor has failed to comply with essential obligation under the lease. To A. If the lessor fails to make the unnecessary repairs, the lessor is obliged to make repairs needed to keep the property fit for its intended use. If such necessary repairs are not made despite notice and the condition substantially affects the use or habitability on the premises, the lease may suspend rent until the repairs are completed. B. Failure of the lessor to maintain peaceful and adequate enjoyment of the property. The lessor must ensure that the lease can faithfully possess and use the leased property. If the lessor causes disturbance, allows third-party interference, or otherwise deprives the lease of adequate enjoyment of the premises, the lease may suspend rent until a disturbance or interference is remedied. The 2 is effect of if cause for the suspension ceases. Suppose the cause for the suspension has ceased to exist. Does the lease have to pay now for the rentals that had been suspended? Answer it is submitted that the answer is in negative. The term suspend here should be constructed to mean that for the intervening period. The lease does not have to pay the rent. A contrary interpretation would cause the lessor to the rent. A contrary interpretation could cause the lessor to procrastinate in the fulfillment of his duties. 3 is effectivity of the suspension. From what moment does the lease have the right to make the suspension? The lease has the right to suspend the payment of rent from the moment the lessor is in default in complying with his obligation. That is, after the lessor has been notified or demanded to make the necessary repairs or to maintain the lease in peaceful and adequate enjoyment of the property, and fails or refuses to do so within a reasonable time. Thus, the suspension does not arise automatically. It becomes effective only after the lease has been made a prior demand or notice to the lessor and the lessor fails to comply with his obligation despite such demand. The right to suspend continues only while the lessor's breach persists. Here are the example. Anna rents a house from Ben. As after a strong typhoon, the electrical wiring becomes exposed and the toilet stops working, making the house unsafe and unfit for living. These are necessary repairs. Anna informs Ben and demands that the repairs be made immediately. Despite the demand, Ben does nothing. Because Ben failed to make the necessary repairs, Anna suspends the payment of rent until the electrical wiring and toilet after are properly repaired. Under Article 1658, Anna's suspension of rent is valid since the lessor failed to fulfill his obligation to make necessary repairs and to maintain the lease in adequate enjoyment of the leased property. So, in Article 1658, allows a lease to suspend rent payment if the lessor fails to make necessary repairs or maintain peaceful enjoyment of the property. But this suspension requires prior notice and is effective only until the issue is resolved. Article 1659. If the lessor or the lease should not comply with obligation set forth in the Article 1654 and 1657, the aggrieved party may ask for the rescission of the contract and indemnification for damages, or only the latter, allowing the contract to remain in force. Comment. Alternative remedies of aggrieved party in case of non-fulfillment of duties. When either the lessor or the lease fails to comply with the obligation imposed under Articles 1654, obligation of the lessor, and 1657, obligation of the lease, the aggrieved party is given the following alternative remedies. Rescission of the contract with indemnification for damages. The aggrieved party may ask that the lease be rescinded or terminated and that the party at fault be required to pay damages for the loss or injuries suffered as a result of the non-fulfillment of obligation. Indemnification for damages only, with the contract remaining in force. Instead of rescission, the aggrieved party may choose to maintain the lease contract and merely demand payment of damages caused by the other party's breach. Rescission and damages. B. Damages only, leaving the contract in force is specific performance. So, number 2 is rescission. Rescission is proper when the non-fulfillment of duties is substantial and defeats the purpose of the lease, making it unreasonable for the aggrieved party to continue the contract. So, here the example. Carlos leases a commercial space from Diana to operate a small restaurant. Under the lease contract, Diana, the lessor, is obliged to make necessary structural repairs and ensure peaceful enjoyment of the premises. After few months, the ceiling collapsed due to long neglected damage. So, Carlos repeatedly demands repairs, but Diana ignores all requests. Because of the unsafe condition, Carlos is forced to close his restaurant and suffers losses. Carlos, as the aggrieved party, may ask for the rescission of the lease contract under Article 1659, plus indemnification for damages such as lost income and repair-related expenses. So, here's some query. If the aggrieved party desires to rescind but the other requests for time within which to comply with his duty, who will prevail? The answer is the court will decide. Rescission is not a matter of right. If the aggrieved party demands rescission, but the party at fault asks for time to comply. It is for the court to determine who will prevail, based on the nature and gravity of the breach, and the interest of justice and equity. If the fulfillment is substantial, the aggrieved parties demand rescission will prevail. If the breach is not substantial and can still be reasonably remedied, the court may allow time to compliance instead of rescission. So 4 is the remedy of damages. Answer. Instead of rescission or in addition to it, the aggrieved party may demand indemnification for damages caused by the other party's non-fulfillment of obligation under the lease. Example. Scenario 1. Lessor at fault. Anna leases a shop from Ben. Ben is obliged to make necessary repairs and ensure peaceful enjoyment of the property. In Article 1654, the roof starts leaking badly and Ben refuses to repair it despite repeated demand. Anna's merchandise is damaged due to the leak. Remedies for Anna: rescission plus damages. Anna may terminate the lease and demand compensation for her damaged merchandise. Number 2, if damaged only, Anna may keep the lease but still claim damages for the losses suffered. In scenario 2, lease at fault, Carlos leases a warehouse from Diana. Carlos fails to pay rent and uses the warehouse for illegal purposes, violating his obligations. In Article 1657, remedies for Diana. 1 is rescission plus damages. Diana may terminate the lease and claim damages for unpaid rent and any losses from the illegal activities. 2. If damage only, Diana may keep the lease in force and still claim the damages for unpaid rent and losses. In Article 1660, if a dwelling place or any other building intended for human habitation is in trust, a condition that is used bring imminent and serious danger to life or health, the lease may terminate the lease at once by notifying the lessor, even if at the time the contract was perfected, the former knew of the dangerous condition or waived the right to rescind the lease on account of this condition. Comment 1. Rule when place is dangerous to life or health. This article, allowing immediate termination of the lease, applies only to a dwelling place or any other building intended for human habitation. B. If at the time the contract was perfected, the lease knew of the dangerous condition or waived the right to rescind on account of this condition. Example, rule when place is dangerous to life or health. Scenario, Maria rents an apartment from Juan. After moving in, she discovers that the ceiling is about to collapse due to termite damage and the electrical wiring is exposed, creating a serious risk of fire. Even though Maria knew about some minor cracks when she signed the lease, the dangerous condition threatens her life and health. Under the law, Maria may immediately terminate the lease without waiting or giving Juan a chance to fix the place. 2. Reason for the law. Public safety cannot be stipulated against. Commission Report, page 142. Example, reason for the law: public safety cannot be stipulated against. Scenario, Rosa rents a small apartment in an old building. The lease contract includes a clause stating that Rosa cannot terminate the lease even if the building becomes unsafe. Later, the building develops structural cracks and faulty wiring, making it dangerous to live in. Despite the clause in the contract, Rosa may immediately terminate the lease. The law protects her because public safety and human life cannot be waived or contracted away even if the parties agreed otherwise. It is ensured that a lease can terminate the lease immediately if the dwelling becomes dangerous to life or health, even if the contract states otherwise, as a public safety and human life cannot be contracted away. That's all for. Thank you.